President.
Senior Senator from South Carolina is recognized.
Thank you. I would like to speak in support of the McCaskill, Ayotte, Fisher, Levin et al. Amendment. Could you let me know when 15 minutes has expired? Thank you. Mr. President, before we get started, I really want to thank Senator Levin, Reed, McCaskill, Ayotte, Fisher, and others who have been trying to carry the burden here to make sure that we reform the military justice system and the way the military operates vis-a-vis sexual assaults and misconduct, but at the same time make sure that we still have a military that can continue to be the most effective fighting force on the planet at a time when we absolutely need it. If you believe, as I do, our military is the best in the world, you have to ask yourself why. Is it because of the equipment? We have great equipment. I would argue that the reason our military has become the most effective fighting force in the world is the way we're structured. If you're looking for a democracy, don't look to the military. The military is a hierarchical and paternalistic organization that's focused on meeting the challenges of the nation, being able to project force at a moment's notice to deter war, and if war ever comes, to decisively end it on our terms. I've been a military lawyer for over 30 years. I've been assigned as a military defense counsel for 2.5 years, a senior military prosecutor in the Air Force for 4.5 years. I've been a military judge. I've served in the Guard, the Reserve, and on active duty for 6.5 years. I have learned a lot as a military lawyer about the military. To my colleagues who are deciding what to do and what's appropriate, the goal should be to make sure that America remains the most effective fighting force on the planet. And here's a proposition. You can't be an effective fighting force if you have rampant sexual assault or misconduct within the ranks. And this idea that sexual assaults in the military are unacceptable, too large in number and scope, sign me up for that proposition. But the problems of society don't stop at the gate. They continue inside the fence. I would dare say that if we did surveys in South Carolina, Missouri, New Hampshire, New York, about sexual assaults and their frequency, we would all be disturbed. And the goal of our time here is to make sure that when it comes to our military, that we turn a corner and that we create a legal system where people feel that if they file a complaint, they're going to be fairly treated. And also a legal system, if you're accused of something, you're going to be fairly treated. To my colleagues, there is a reason that every Judge Advocate General of all the services have urged us not to adopt Senator Gillibrand's solution to this problem. In the military, it is impossible, in my view, to correct a problem without commander buy-in and holding commanders responsible. Military commanders have awesome responsibility and almost absolute liability for the job that we give them. It is their job to make sure that all under their command are ready to go into combat, perform their assignment in the most difficult task, to make sure that your medical records are up to date, to make sure that you're squared away when the nation needs you. This concept of the authority of the commander goes back to the very beginning of this nation. Military justice is an essential part of good order and discipline. After 30 years of experience in this area, the number of cases where a judge advocate recommends to a commander that you proceed to trial in a sexual assault, or for that matter, most any other alleged crime, is a rounding error. So please don't suggest that our current system, that you can't get a case into trial because our commanders routinely blow off legal advice. That is not the case. Commanders decide as to whether or not to proceed to a court-martial and what level of court-martial based on advice of the judge-advocate community, whose job it is to provide professional advice. The commander's job is to make sure that unit is ready to go to war. The lawyer's job is not to pick and choose who goes into the battle. The lawyer's job is to give that commander the best legal advice possible, including who to court-martial and who not. But one thing that I hope you understand in this debate, that no lawyer, no judge advocate is ever going to have to deal with the situation of picking and choosing in that unit who takes the most risk. We have, for 200 years now, allowed commanders the authority under the Uniform Code of Military Justice since 1952 and before, the ability to maintain good order and discipline, the absolute responsibility to make sure the force is effective when it comes to the fight, and giving them the tools to make sure that happens. What would bother me greatly is this conversation occurred. Sir, ma'am, depending on who the commander is, there are more and more female commanders in the military. There was an alleged rape last night, a sexual assault in the barracks last night, and the commander would say, that's no longer my problem. Send that to Washington. Ladies and gentlemen of the Senate, that is the commander's problem. And to those commanders who have failed to make sure that we have the right climate in the military when it comes to sexual assault, your job is at stake. The military justice system, when it comes to rendering justice, I will put up against any system in your state. The reforms in this bill are going to become the gold standard, I hope, over time, and very few jurisdictions will be able to do what we've been able to do. Thanks to Senator McCaskill, Ayotte, Levin, and others, we have taken a problem in the military and I think brought a good solution. Every victim will now be assigned a judge advocate to help them through the legal process. I wish that were true in South Carolina, but it is not. Every commander who is advised to go to trial in sexual assault cases and who declines to accept the JAG, the judge advocate's recommendation, that case is automatically sent up to the Secretary of the service in question. So in the future, as commanders have to decide how to deal with sexual assault allegations, when the lawyer tells them, sir, ma'am, this is a good case, and if for some reason the commander decided, I disagree, that case goes up to the highest civilian member of that service, the Secretary of the Air Force in case of my service. That, to me, is a reform that will emphasize from the chain of command how important it is that we take these cases seriously. If we take the chain of command out, here's what we're saying in my view. To every commander in the military, you're fired. We, the United States Senate, have come to conclude that you, the commander, all commanders as a group, are either intellectually insufficient to do this job, or you just don't have the temperament, or you're morally bankrupt. We're going to take away from you this part of being a commander. You are fired. I will never, ever say that until I am convinced that there is no hope for our commanders, that our commanders are hopelessly lost when it comes to these type issues, I don't believe we're remotely there. In the 1970s, you had upheaval throughout the country, particularly in the military. We had race riots on aircraft carriers, and tension ran high. How did we fix it? We made sure that every commander was held responsible for the atmosphere in their unit when it came to race relations, and now I would dare say that the most equal opportunity employer in the whole country is the United States military, because commanders change the climate. Under Senator Gillibrand's approach, we take out a group of military offenses to the commander: you're fired, you can't do this anymore. And we send these decisions to an 06 judge advocate, which I happen to be one, by the way, in Washington. I cannot stress to my colleagues enough how ill-conceived this system is from a military justice point of view, and the damage you're going to do to the command and to the fighting force if you go down this road. And let me tell you why. You're in Afghanistan. There is a larceny, and you talked about employment. Senator Coons mentioned workplace. A barracks thief is one of the worst things you can do in the military. You don't pick and choose who you room with. We pick who you room with. You don't get to decide where you're going to stay. We pick for you. We throw you into the most incredible conditions. We don't give you the comforts of home, and you have to trust your fellow soldier in the barracks and in deployment. And soldiers, like everybody else, most are great, some are bad. In the military, the bad apples, thank God, are a few. But under this construct we're coming up with, if you were in a deployed environment and there was a barracks theft case, a tent theft case, that really does hurt morale, because if you got to worry about somebody stealing your stuff, that's really tough given the conditions you're living under. The commander could not deal with this. It would go all the way to Washington, D.C. to be disposed of, rather than being disposed of on site. And why does it need to be disposed of on site? You need to render justice quickly, effectively, so the troops can see what you're doing. And if you're the commander, they have to respect you, and they have to understand your role. So I cannot understand why the United States Senate, when we've been at war for 11 or 12 years, would come up with a solution to a problem that's real, that does harm to the very concept of what makes our military special. The ability to go to war, the ability to be effective, and have the commander make decisions that only a commander should be making. I'm a military lawyer. I am telling you right now, don't give me this decision, because I'm not required to decide who goes to battle. Don't take away from our commanders in a theater of operation the ability to render justice in a way that the troops can see.
Mr. President, would the senator yield for a question?
Yes.
I want to make sure I understand something about non-judicial punishment. Since you're on the barracks thief in Afghanistan, and the notion that everything is going to stop and we're going to send this case off to a lawyer half a continent away to make a decision, let's assume that the lawyer, the colonel over in Washington, decides there's insufficient evidence for that barracks thief. Now, that might be 4 months later. Meanwhile, the barracks thief is still there, and let's assume then it comes back. It's my understanding, and I think there's some confusion about this by the people who are advocating this amendment, that you cannot exercise non-judicial punishment on a soldier if he chooses a court-martial proceeding. Is that correct?
That's exactly right. And non-judicial punishment is an authority the commander has to put people in confinement for up to 30 days, reduce in rank 1 or 2 levels depending on the rank of the commander, and to withhold pay. It is non-judicial punishment. You don't have a trial. The person is represented by a lawyer, but there is no jury. The commander is the jury.
So that commander...
The senator has spoken for 15 minutes.
Okay.
So that commander who has to now send the
Loses
barracks
that
thief
authority.
case to Washington, that soldier is not going to agree to non-judicial punishment. He's going to say, I'll take my chances with the lawyers in Washington, and if the lawyers in Washington say no, then that commander's hands are completely tied to even put him in the barracks for 30 days. I mean, in the brig for 30 days.
Exactly right. Every military lawyer who's looked at this is very worried about what we're about to do in terms of practical military justice. Now, if you're 18 years of age, you have too much to drink, you write a bad check. Part of being a commander and a first sergeant is the paternalistic aspect of the job. How many of us have made mistakes at 18? Instead of going to college, you're going into a military unit. You bounce 4 or 5 checks. Has that ever happened? Under this system, the military commander no longer has the ability to deal with it in the unit. You send that case off to Washington. The ability to give a Article 15, a lesser punishment, is taken off the table. You're taking an 18-year-old mistake and potentially turning it into a felony. Now, does that help sexual assaults? Our commanders can send you to your death, but we don't trust them to deal with manslaughter cases. All I can tell you, for 30 years, I've been a practicing military lawyer, and from my point of view, our commanders take the responsibility to impose discipline incredibly seriously. They're skilled men and women, and we have let the soldiers, sailor, airman, Marine down when it comes to sexual assault. All of us are to blame in the military. We're going to fix that, but the problem, ladies and gentlemen, is not the military justice system. We don't have a military justice system where commanders tell the lawyer, go to hell, we're not going to deal with that. That's not the way it works. This new system takes a portion of offenses out of the purview of the commander and sends them to somebody in Washington that nobody in that unit will ever get to see, that will delay justice, will take tools off the table to make sure that is an effective fighting force in terms of dealing with the barracks thief, in terms of dealing with the bounce check, but also is taking young people who make mistakes and putting them in an arena where they're the only avenue is to be charged potentially with
Would the senator
felony.
from South Carolina yield for another question?
Yes.
So under this situation where you said that we have commanders that aren't going to ignore what is brought before them in an investigation from their JAG lawyer, particularly on a sexual assault, let's assume that they did do that, even though the evidence isn't there that they do it. Under our proposal, the proposal that I have, that Senator McCaskill has, and Senator Fisher, that decision, if the commander makes the decision not to bring the sexual assault case, it then goes up for review to the civilian secretary of the whatever force is at issue, the Army, the Air Force, and the Navy. So what do you think that would do in terms of accountability?
If you want to improve the system, and we all do, I'm not questioning anybody's motives, if a commander knows that when they turn down the JAG's advice in one of the 4 situations we've identified, sexual assaults, the nature of the discussion here, that decision will be reviewed by the Secretary of the Service, I can assure you that will do more good to make sure commanders understand how important this situation is to us in the country than taking their authority away. You're doing absolutely the worst possible thing to solve the problem from Senator Gillibrand's approach, in my view, but every judge advocate agrees with what I'm saying. You throw the military justice system in chaos, you basically take the commander's authority away in an irrational way. What you do is you hold the commander more accountable by having what is the commander's worst nightmare, I guess, anybody in the military, having the boss look at your homework. How do you get promoted in the military? People over you judge your work product. And let me just say this, it is not a military justice problem here. The reforms that we're going to engage in are historic, will be the model for systems in the future, but very few people can afford what we're about to impose upon the military, because we're going to make this a priority, and we're going to assign judge advocates to victims, and there's no other state in the nation that's going to be able to do that. We're going to have something you should be proud of. We're going to hold commanders more accountable. Here's the essence of the argument. You've got to take this out of the chain of command, because there's something defective about the commander. Because the commander doesn't have the ability, or they have a bias against victims, that you no longer can trust them to do the right thing. That, to me, is an indictment of every commander in the military that I think, quite frankly, is not what we should be doing or saying, given the track record of how our military has performed. In the area of sexual assault, the problems that you see in the military are all over the country. They're just talked about more in the military. The people in the military should be held to the highest standard. But you will fix no problem in the United States military if you deal that commander out.
The senator yield for a comment. And in fact, the evidence is, looking at the facts, that commanders are bringing more cases, are pursuing more cases than over the recommendation of their JAGs in sexual assault cases. The evidence that we've gotten from a letter we received from Admiral Winnefeld, the deputy of the chairman of the Joint Chiefs of Staff, basically he had pointed out that there were over 90 cases, in fact, where commanders had a different view than their JAG, said a case should go forward, and guess what? Convictions were had and people were held accountable.
There are situations where joint jurisdiction lies. The military has jurisdiction, the civilian community has jurisdiction. There have been cases where the civilian community went first. There were 49 cases in the Army where the civilian community decided not to prosecute in sexual assault that the Army took up, and they got an 81% conviction rate. In the Marine Corps, 28 cases turned down by the civilian community where the Marine base was at that went to court, 57% conviction rate. In the Navy, in the Air Force, it's the same thing, where you have civilian jurisdiction saying no to the case, the military saying, yes, we're going to go to court, because there's a difference between what the civilian community is trying to accomplish and what the military community must be trying to accomplish, and that is to let the troops know that their certain conduct is out of bounds, and if it's even close, you're going to pay a potential price. Now, having said that, please do not blame sexual assault problems in the military on a broken military justice system, because it is not broken. The commanders are not telling the lawyers take a hike. The cases the lawyers recommend to go to trial actually do go to trial. And juries in the military, it's not a juries of one peers. This is not a civilian system. Everybody who goes to trial as an enlisted man is judged by officers. You can request 1/3 of the military jury to be enlisted members, but they're going to be the most senior people on the base. Please understand that military juries are not constructed the way civilian juries are. They're told to be fair, and they do their best to be fair. But it goes into the concept of how the military works. The only person entitled to a trial in the military of equivalent rank is an officer. An officer cannot be tried by people of lesser rank. And that may sound unfair, but in the military it makes perfect sense, doesn't it, Pat? Officers eat in one corner of the base, and enlisted people eat in the other corner of the base. Not because they hate each other, they admire and respect. This chain of command, these lines of authority, make us, I'd ask for 1 extra minute if I could.
Sir, objection. So ordered.
Thank you. This unusual situation for most Americans works in the military. It may not sound right to you, but it works, because the military is about, when you're ordered to do something, you answer the order. You don't debate. So if we don't elevate the commander to have the tools available to make the right decisions, and if we don't instill those below the commander to follow, it all breaks down. And when a commander lets the troops down, and they do sometimes, fire the commander. Don't take away the authority of the commander to win wars that we will inevitably fight. This is not a civic organization. This is not a democracy. This is a situation where one person can choose to send another person to their death. That person is the commander. And there are plenty of checks and balances. Ladies and gentlemen, sexual assault is a problem, but for God's sakes, let's don't tell every commander in the military, you are fired. You are morally bankrupt. You're incapable of carrying out the duties of making sure that justice is done in these cases.